Suppose you buy a plot, you spend your life savings, you verify the title, you check the revenue records, the government grants you the permission, the municipal corporation also issues you a registered patta. You pay every charge that the government asks for. Years pass. Then one fine morning, you receive a notice from the government. The notice says that the patta that has been issued in your favor stands cancelled. Not because you have forged any document, not because you have committed any fraud, because the government now says that the patta should never have been issued in the very first place. Now ask this question to yourself. Can the government really do that? Can it first issue a registered patta and then turn around and cancel it? That was the question before Rajasthan High Court in the case of Vikas Modi versus State of Rajasthan. Hello, I am Advocate Naman Dhadij. Let's understand what the court actually decided in this case. Most people think that once a document is registered by the government, their title is safe for eternity. Legally, that assumption is not always correct. This judgment explains why. Because it also teaches us something bigger. The relationship between private property, urban planning, environmental protection, and governmental accountability. Let us understand the facts of the case. The dispute in this case was concerning a land situated at Diwanji Ka Bagh, that is in Alwar. And the petitioner claimed title through a long chain of transactions. Gift deeds, succession, sale transactions, revenue entries. Eventually, after that, proceeding under Section 90A of Rajasthan Land Revenue Act 1956 were initiated. Permission for non-agriculture use of land was granted. Thereafter, the municipal corporation issued a registered patta in the favor of petitioner. Naturally, the petitioner believed that everything that has been done is in accordance with the law. But this was not the end of the story. A show cause notice was issued to the petitioner. The allegation was very serious. The land, according to the authorities, formed a part of the green belt under the master plan of 2031. If the allegations were correct, the very foundation of the conversion proceeding became questionable. The municipal corporation ultimately cancelled the patta under Section 73 of Rajasthan Municipalities Act 2009. At the same time, the state government also declared the earlier proceeding that was under Section 90A to be void from the very beginning. The petition challenged both orders before Rajasthan High Court. Now, many people think that this is a case about ownership. It isn't. Ownership was only a part one. The real issue was way larger than it was thought to be. Can a statutory planning law override a registered property document? Or, to put differently, if a government itself issues an illegal patta, does registration make that illegality disappear? This is the real question. Here in this case, we need to understand three legal provisions. Without these, the judgment cannot be appreciated to its totality. Let's begin with Section 90A of Rajasthan Land Revenue Act 1956. This provision empowers the competent authority to permit the conversion of agricultural land for non-agriculture purpose, such as residential, commercial or industrial use, subject to the conditions prescribed by the law. This provision empowers the competent authority to permit the conversion of agricultural land to non-agriculture purpose, such as residential, commercial or institutional use, subject to the condition that has been prescribed by the law. Now, this power is often misunderstood. Many people assume that once an order under Section 90A is passed, the authority has given the land to completely new legal character, and every subsequent permission automatically becomes valid. This is not the law. Section 90A is an enabling provision. It enables conversion only within the frameworks of the law. It does not override Rajasthan Urban Improvement Plan, the Rajasthan Municipalities Act, the provision governing plan development area or the statutory master plan applicable to these areas. In other words, the authority exercising power under Section 90A cannot be permit what another statute expressly prohibits. If a master plan reserves a particular parcel of land as a green belt area, the authority cannot, by merely passing a conversion order under Section 90A, transform that land into residential or commercial property, because statutory power must always be exercised within the limits of the law, never contrary to it. This principle forms the foundation of this judgment. And now let us move to the Section 73 of the Rajasthan Municipality Act 2009, which lies at the very heart of this dispute. The provision recognizes an important principle in the public law. Merely because a municipality has executed and registered a lease deed or issued a patta does not automatically mean the document becomes immune from scrutiny forever. Section 73 authorizes the municipality to revoke or cancel a patta, lease deed or any other allotment if it finds that the document was obtained through fraud, misrepresentation or suppression of material facts, collusion or in contravention to the provision that has been existing in the state. However, and this is equally important, the legislature has built the procedure safeguards into this provision. The power cannot be exercised arbitrarily. Before any cancellation takes place, the affected person must be given a notice, an opportunity of hearing, and the authority must record that reason for arriving at its conclusion. So the provision balances two competing public interests. On one hand, it protects public land from illegal allotments. On the other hand, it protects the citizen from arbitrary administrative action by insisting upon compliance with the principle of natural justice. Now notice one particular expression used in this provision, that is, in contravention of law. These four words ultimately become decisive in this case, because the court concluded that the patta has been issued contrary to the statutory master plan. Section 73 itself furnished the legal authority to revoke it. The third provision is perhaps the most important of all, the master plan. Very often people think that the master plan is merely a planning document or a set of administrative guidelines. It is neither. A duly notified master plan derives its authority from governing planning statutes and possessing a statutory force. It is binding upon everyone. It binds individual landowners, it binds municipal corporations, it binds development authorities, it binds officers existing in statutory powers, it binds everyone, and most importantly, it binds the government itself. It is a legislative instrument intended to regulate planned urban development, preserve environmental sensitive areas such as green belt, maintain ecological balance, and ensure orderly growth of cities and prevent arbitrary changes in land use. Consequently, no other authority exercising statutory power can grant permission, issue patta, approve conversion, or regularize construction in a manner that defeats or nullifies the notified master plan. Doing so would not merely be an administrative irregularity. It would amount to exercising statutory power without authority of law. And that is precisely why the High Court repeatedly emphasized that master plan is not optional. It is binding upon everyone. In this case, the court first examined whether the land actually fell in the green belt area. The court found that there was no real dispute on that point. Even the material relied upon by the petitioner showed that the land was to be part of the notified green belt area. Once the conclusion was reached, the rest of the judgment followed almost inevitably. The court held that the authorities exercising power under Section 90A could not ever permit the land use contrary to the master plan. Such an order would be without jurisdiction, and if the foundational order is itself without jurisdiction, every subsequent action built upon it, including the register patta, also collapse. We lawyer calls this doctrine that when a foundation falls, the superstructures cannot survive. The court said something every purchaser should remember. A registered document does not automatically legalize an illegal transaction. Registration proves that document was registered. It does not cure a defect that goes to the root of its legality. This is why the court rejected the argument that registration itself protected the patta. In this case, the petitioner also argued that cancellation of patta has violated Article 300A of Constitution of India. Article 300A protects the right to not to be deprived of its property, except by the authority of law. This was a really attractive argument, but in finality the court rejected it. Why? Because of the reason that Article 300A protects lawful property rights. It does not constitutionalize rights created through action to be found contrary to the law. If the cancellation itself is authorized by a statute, there is no violation of Article 300A. Now this is where the judgment goes beyond to the dispute between the parties. The court noticed that public official had processed conversion, regularization and issuance of patta, despite the land forming a part of the green belt. The court observed that such kind of conduct either reflects the gross negligence or deliberate circumvention of the statutory provisions. Accordingly, the court directed to the state government to identify the officers involved and initiate departmental inquiries against them after following a due process. This transformed the judgment. It is no longer just a property dispute. It becomes a judgment on public accountability. So what lessons should an ordinary citizen take from this judgment? First, never assume that registration alone guarantees legality. Second, before purchasing a land, verify not only the title, but also the master plan, land use, zoning, and planning permissions. Third, if the patta has been issued contrary to the statutory prohibitions, the municipality may still possess a power to cancel it, provided by the law authorize such action, and due procedure has to be followed in this case also. This judgment is not really about one patta in Alwar district. It is about something very large. Can statutory authority ignore the master plan? The Rajasthan High Court has answered in this case. The answer is no. The second question is, can registration validate an illegality? Again, the answer is no. Can public officials escape accountability when statutory planning laws are ignored? According to this judgment, they should not. Thank you for watching. If you find this analysis helpful, read the judgment by yourself. Compare with the statutory provision and let me know in the comments whether you agree with the court reasoning or not. I'll see you in the next judgment analysis.